So let's look at what happened here in Decina. This is a tragic case, and at its time it was actually quite a famous case. There's Mr. Decina on a very beautiful day, no weather implications, driving down the street, veering left, veering right, jumping the curb, and hitting 4 children on their way to school. Not only hitting them, but continuing past them, more veering and swerving, all the while speeds are accelerating until he crashes into a block wall at the grocery store. And we're going to add some more facts in. Horn is blaring, Mr. Decina is slumped over the wheel, and he actually says when he gets out of the car, "I think I passed out. I blacked out under the bridge." What's his argument? He killed those children. He was driving, and I'm going to put in quotes, driving the car. What's his argument on why he shouldn't be guilty? Mr. Decina has an important legal argument. What he is saying is, you need to look at my actions to figure out if I did a legal actus reus. Did I in fact operate the vehicle? And his argument is, I couldn't have operated the vehicle legally because I was unconscious. And it was while I was unconscious that the car veered and swerved, while I was unconscious that the car sped up and hit those children. So if I'm unconscious, you can't charge me legally because I didn't do an act over which I had physical control. Sounds a little bit like our woman who killed her daughter. She was sleepwalking. Mr. Decina says he was unconscious. So this is really interesting. Everybody agrees he was unconscious. The witnesses, he says he was unconscious. So if he's unconscious, why does he lose? The key here is that the court believes he still committed an actus reus over which he had physical control. The court says you committed a voluntary actus reus even though you were unconscious. How do we prove that? Can you pinpoint when that occurred? When did Decina commit that actus reus over which he had physical control? For the court, it was easy. The court said when you got into that car voluntarily, you knew that you had the potential for seizures. When you got into that car voluntarily, you knew there was a risk you could have a seizure. Not only that, the court says, you knew that an uncontrollable car, an unmanned car, could wreak havoc on a public highway. How did the court know that Decina knew he was engaging in a risk? The reason is his compelling history of seizures. Look at how many seizures he had prior to the accident. In a 4-year period, he had 10 to 20 seizures, and his most recent seizure was only a few months previously. In fact, I want you to turn to the second page of the opinion. Part of our reading cases is actually figuring out why the court uses the words it uses. I call it drafting opinion 101. The second paragraph of that second page of the opinion really tips us off as to what the court is thinking. The court says, in our opinion, he did know about the seizures. Look at how many times the court uses the word know or knew or variations on that word. The court says, this defendant knew he was subject to epileptic attacks and seizures that might strike at any time. He also knew that a moving motor vehicle uncontrolled on a public highway is a highly dangerous instrumentality. And then the court says, with this knowledge, he deliberately took a chance to make a conscious choice of a course of action. For the court, this was not like having a first heart attack. This was like a drunk driver getting in the car knowing he was drunk. Mr. Decina got in the car knowing that he might be subject to a seizure. And if you think about theories of punishment, this makes good sense what the majority is saying. First is retribution. You should be blameworthy because you made that conscious decision to get in the car and drive even with the risk of having a seizure and the risk of what an uncontrolled car might do. And we want to control future behavior. That's called deterrence. If the court punishes Decina here, that will control other people's future behavior. They'll think twice before they get in a car subject to a seizure. But now I want you to turn to the dissent's position. To the dissent, Decina is like a person having a first heart attack. The dissent is very concerned by making Decina blameworthy for acts he did when he was unconscious. And I want you to look at a couple of lines in the dissenting opinion. The dissent engaged in a tactic that's quite persuasive. We call it bringing out the list of horribles or the parade of horribles. So the dissent wanted to show how difficult this decision was that the majority was creating. And how did the dissent do it? It listed all the other kind of diseases or illnesses or conditions that Decina could have had that would have made him guilty. So let's look at this list of horribles. Epilepsy, coronary involvements, circulatory diseases, nephritis, uremic poisoning, diabetes, Meniere's syndrome, a tendency to fits of sneezing, locking of the knee, muscular contractions. To the dissent, any of these conditions could have been the same as Decina having become unconscious because he was having an epileptic seizure. So what's the takeaway from this case? We actually have two general principles of Actus Reus that we've discussed in this lecture. The first principle is that in general, defendant has to have physical control over his actions. But we actually have a second corollary to this position, and that is we might discover that he has committed an actus reus if we can find a voluntary act that occurred earlier, coupled with knowledge of a risk of a later involuntary act.